So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital
England and
revolution.
Wales are embracing alternative dispute resolution, and we're going to talk about that today. Alternative dispute resolution, or ADR, is a set of methods used to resolve conflicts and disputes outside of traditional courtroom litigation. It's a more flexible way to reach agreements and find solutions. They include mediation, arbitration, negotiation, and collaborative law. Ultimately, ADR processes prioritize open communication and the exploration of mutually beneficial outcomes. They can be pretty useful when parties want to maintain relationships, they want to save time and money, or keep things private. ADR has gained popularity due to its potential to provide quicker and less adversarial solutions compared to traditional litigation. So recently, the Courts and Tribunals Judiciary Judge Barry Clark, who's the president of the Employment Tribunal for England and Wales, he put out a presidential guidance that concerned the way that tribunals were being run in England and Wales, and it superseded previous rules. And it was a result of mediation that was fairly successful during COVID through telephone and video. Now, in this manner, so arbitration is particularly successful, or perhaps not successful, but widespread in the United States, where arbitration is often a way that you can sort of sign away your rights. Many employers have a method of arbitration so that if you have, for example, equal employment opportunity issues, if you have discrimination issues of any kind, wage issues, you would sign a document either, at employment or, later on during your employment career that says that you will handle those concerns that you have with the company through alternative dispute resolution rather than with the law. And the government often respects these. And it's really a problem, right? I mean, this is a situation where a company is leveraging their power to utilize arbitration outside of the rule of law. And, those make me feel very uncomfortable. It's not a great deal. But England and Wales, the employment tribunal has found another way because they're starting to get a backlog. They're starting to get a whole lot of employment claims that need to be resolved, and they don't have the means to resolve them. The presidential guidance that was put out really, hit home the cost that it took. In employment tribunals, each side generally bears their own costs. Orders to pay the other side's costs are rare. And ultimately, there's a cost borne by the public where they have to pay for these systems of judges, which include a judge, a clerk, a hearing room, et cetera, et cetera. And so these employment tribunals are becoming very expensive for England and Wales. They think they can do this by using ACAS. ACAS is the Advisory, Conciliation, and Arbitration Service, which is an independent public body in England, Wales, and Scotland. They play a crucial role in promoting good employment practices, preventing and resolving workplace disputes, and offering guidance on employment-related issues. When they use judicial mediation, which is outside the normal system, it's focusing on cases that are listed for 3 days or more. They're usually about discrimination and whistleblowing, and do have more complex claims of unfair dismissal. With a judicial assessment, they can be used with any case, and an employment judge will use their skills and experience based on the information available at the time to give the parties an evaluation of their respective prospects of success and possible outcomes in terms of remedy. So judicial assessment kind of gives you the idea of where you're going to stand, whether or not you're going to win or lose before you get in place. And so that's a great way. You have an official judge to give you an idea so that you can either decide to pull out from the case or to go forward, and likewise have the employer make the same decision whether or not they think it's worth fighting or not. Finally, there's the dispute resolution appointment, which is a case is listed for 6 days or more, and it's the need for these appointments arise because of the high number of discrimination, whistleblowing, detriment that populate the outstanding stock of cases. Dispute resolution appointments are non-consensual. The tribunal arranges such an appointment if the parties do not desire one, and it's the only one. Now, all of these, besides the final one, is consensual. You get the choice to agree upon this with both with both claimants, both the plaintiff and the defendant. And so I think that these sort of outcomes can be really, really valuable. These sort of methods of managing these cases can be really valuable because companies can be tied up in these courts for a significant period of time, and there's no real outline or outlet for them. Same with the employees. I once knew an employee who had an equal employment opportunity claim that had been sitting out there for over 6 years with a specific state, and that's because the state refused to adjudicate it one way or the other. Potentially because the person had no case, and it was just, I don't know that they wanted to deliver that news or something. I really don't know, but even in the United States, equal employment claims can take a significant amount of time and resources for both parties. And so having these non-legal, non or out, extrajudicial methods of managing employment claims and discrimination claims could be really useful. And that's what they've seen in releasing this presidential guidance is the opportunity to embrace alternative dispute resolution as a means of getting outlet for their kind of overburdened judicial system. Let me know what you think about ADR or alternative dispute resolution. It's definitely a hot topic in the negotiation slash human resources world right now, and it continues to be more and more popular. But let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.